Okay, we'll go on the record in People versus Blake Christie. This is file number 244933. The record should reflect that Mr. Christie is present today by video from Department of Corrections. If I could have counsel put your appearances on.
Brian Ziegler, on behalf of the people, Your Honor.
Thomas Ziegler, here with on behalf of Mr. Christie.
All right, this hearing was set as a resentencing hearing pursuant to a notification by the Department of Corrections that the court omitted what I view as a statutorily required term of the sentence pursuant to MCL 750.5.10, which is lifetime electronic monitoring. So the court set this for a hearing today. Mr. Ziegler, do the people take any position on whether or not the court is required to order that statute?
Your Honor, did the court receive my response to the defendant's memorandum?
Did it? I'm sure that you sent it. I mean, just not have forgotten it. Yes. Thank you.
Essentially, Your Honor, there is a case cited in my memorandum by the name of People versus Comer, Michigan Supreme Court case. Dealt with a very similar issue where lifetime electronic monitoring was not ordered. The court considered whether either the court rule cited by Mr. Seeger or whether the invalid sentence rule would allow the court to correct the error. At that time, the rule did not allow for the court to sua sponte correct an invalid sentence. And so the court found that it was an error, but that the court could not sua sponte correct it. Shortly after that, in 2018, the court rule was amended to allow courts within 6 months of the date of sentencing to sua sponte correct such errors. So in light of People versus Comer, in light of the change in the court rule for motions to correct an invalid sentence, which allows the court to do so sua sponte, I think the Comer case establishes this exact situation was in fact an error, and that the court rule change does allow the court to correct that error.
Okay, thank you, Mr. Seeger.
Your Honor, I would just rely on my brief.
Okay. I did get Mr. Seeger's written submission. I had a chance actually I didn't look at the Comer case cited by the People, but I did review the court rule. And the court finds that there is a basis under the court's ability to correct mistakes that render a sentence invalid. And the court finds that it does have the jurisdiction to do that. This is a matter where the court finds that it was statutorily required to impose that term. It was clearly a form mistake. The court neglected or failed to impose that term at sentencing, even though it was one that the court was required to impose. And because the court has jurisdiction to correct those kind of mistakes, the court is going to do that. So the court is going to add a term to the sentence pursuant to, again, 750.520N of lifetime electronic monitoring. The court does need to update jail credit. Ms. Wagner, do you have an updated?
I do, Your Honor. From November 5th, the last date that he was sentenced to date, he has an extra 62 days jail credit, so totaling 279 days to date.
Okay, so the court will impose all the same terms and conditions of sentence with the addition of the lifetime electronic monitoring and the updated jail credit as indicated by Ms. Wagner. Mr. Seeger, is there anything else we need to address on this file today?
No, Your Honor.
Mr. Ziegler?
No, Your Honor.
All right, Mr. Christie, that concludes this hearing and the court's going to disconnect at this time.
Okay.
Next matter is People versus David Yoder, case number 244973. Executive counsel, put your appearances in.
Brian Ziegler, on behalf of the people, Your Honor.
This is set as a show cause hearing today. Mr. Yoder failed to appear for a hearing back on December 3rd. Mr. Seeger, has he tried to contact you in any way?
He's not, Your Honor, and I'm not sure what the situation is.
Mr. Ziegler, do the people take any positions?
Your Honor, well, it's not the crime of the century yet. Clearly, he failed to appear the last time. He's not here today. It is a felony matter. I do think the court really has no other option but to issue a bench warrant at this point.
Okay, the court finds based on Mr. Yoder's repeated failure to appear, that his bond should be revoked. So the court will order that his bond be revoked. It will request the people to prepare a bench warrant for his arrest. Once he's arrested, the court will order that he be held without bond pending, and the court will schedule a bond hearing and status conference at its next available date after he's apprehended. Our next matter is at 9:15. So we'll take a short recess until that time. Okay, we're on the record in People versus Kylie Wheeler, case number 244975. If I can get counsel for their appearances on.
Ryan, good work. Yeah.
Thomas Seeger. Did you call Miss Wheeler's case, sir?
Yes.
Miss Wheeler?
This is the date and time set for sentencing in this matter. I'm in receipt of a report from Ms. Wagner at probation indicating that Ms. Wheeler did not cooperate with the pre-sentence process. Is that correct?
That's correct, Your Honor. She did call me last week, right before the last kind of break with the holidays. She said she's been having some difficult times and issues. She'd been meaning to reach out to me. She hadn't turned in her PSI packet or anything. I directed her and encouraged her to report today for sentencing.
Okay. Mr. Seeger, has she made any kind of contact with you?
I have spoken to her, Your Honor, and apparently she had some kind of medical situation of some sort this morning. Not entirely sure what it was, and it probed very deeply, and I didn't speak to her directly. I spoke to her father. And so in any event, I'm not sure if she's going to appear or she's not going to appear. I'm hopeful that she will, but that's all I can really tell you.
Okay. All right. The hearing was set for 9:15 this morning. It's now 9:20. In light of her failure to cooperate with the pre-sentence report, which would have nothing to do with any kind of medical situation this morning, and her failure to appear, even though she did contact counsel, we don't have any kind of documentation, and I guess I misspoke. She didn't contact counsel, a family member did. In light of all those facts, the court finds it would be appropriate at this point to revoke her bond and issue a bench warrant for her arrest. Once she's arrested, the court will order that she be held without bond so that a pre-sentence report can be prepared, and the court will set sentencing at its next available date following that. The next hearing is set for 9:30. So
money's coming from, you pay his restitution.
Okay, we'll go on the record in People versus Cassandra DeGroat, case number 244913. Again, counsel, put your appearances on.
Brian Ziegler on behalf of the people, Your Honor.
Thomas Seeger, appearing on behalf of Mr. Gray.
So this was set for 9:30. It's 9:45. Mr. Grote is currently lodged in the Department of Corrections. Just for the record, Mr. Ziegler, you did read her from Department of Corrections by video.
Your Honor, there was a writ for Huron Valley Women's Complex for today at 9:30. She was supposed to be brought via Zoom.
Okay, Mr. Seeger, were you able to communicate with her?
I haven't, I attempted to communicate with her prior to her being sent to the Department of Corrections, but then I had called Grand Traverse County Jail. They informed me that she had been shipped. So in any event, I have not had an opportunity to speak with her. Additionally, Your Honor, prior to that, and I'm not sure exactly what happened with it, she was in district court facing an extradition hearing. So I don't know if she got extradited. When I was speaking with the Department of Corrections, they had indicated that the other state might come and get her at the expiration of her sentence to Michigan. But I don't know exactly how that works either.
So it's possible that she's not even at Huron Valley right now.
I guess it's possible, when I had called, originally I had called, I think I sent an email to your clerk in the Department of Corrections indicating that the district court in Traverse City had indicated that there was a extradition hearing for her. And then that was set past the date of her sentencing in Grand Traverse County Circuit Court. So what happened thereafter, I guess I don't know.
Okay. All right. I'm going to reset this one more time for next month. Mr. Ziegler, if you can prepare another writ and if both counsel can make some inquiries, if we can find out exactly where she's at. And we'll try to proceed with sentencing again in February. And we'll go from there.
The only thing that I would know, and because presumably she's under sentence to the Department of Corrections, presumably she doesn't receive credit up until the time that she's sentenced. Because there's delay not through her own malfeasance, like it's not as though she could only not appear because of wherever it is that she's at. Does she get credit for the time up until the time, even though technically she wasn't sentenced today, would she get credit for that time?
Yeah, we've had this come up, periodically within my 3 counties where, especially when COVID was going on, but even since then, we're at Department of Corrections for whatever reason, they have a lockdown or something happens where they can't make the defendant available through no fault of the defendant. I typically will grant some credit because if it turns out that doesn't have anything to do with Mr. Grote, then I don't think it's fair to not grant them credit. So,
Thank you.
yeah. Okay, thank you. Mr. Travis, are you ready on Ms. Weaver's case?
Yes, Your Honor.
Versus Weaver, case number 244983. Record should reflect that Ms. Weaver is present here in the courtroom today. Thank you.
Brian Ziegler on behalf of the people.
I'll Travis on behalf of Mrs. Weaver.
This is set as a status conference today. Mr. Travis, can you tell me the status?
Yes, Your Honor. We did waive a prelim based on a plea offer. We're not ready to complete the terms of that offer. We are hopeful in the next month we will be. Given the nature of this case, that's a situation of coming up with a large sum of money. We are able to pay and agree on some of the restitution. My understanding is the prosecutor would be offering a 1-year misdemeanor. And that's our goal. And speaking with Ms. Weaver and her husband, I do believe hopefully in the next 30 days, we can have some movement on that.
All right, Mr. Ziegler, any objection?
No, Your Honor.
Ms. Weaver, have you had a chance to speak with Mr. Travis about this?
Yes.
Is that how you want to proceed? So the court will set this for a plea hearing in 30 days. Go forward from there. Anything further, Mr. Travis?
Nothing further, Your Honor.
Mr. Ziegler?
No, Your Honor.
Thank you. That's all for today. Yeah, Mr. Chapanier, we have Mr. Chapanier here.
No, he
Sorry,
is not live.
Ms. Wheeler, your honor, I don't know if you understand what he said.
We'll go forward with sentencing with Ms. Wheeler. If you want to come forward. Um, Oh. Christie? No, there isn't one. I forgot. All right, we're on the record in People versus Wheeler, case number 2449775. Ms. Wheeler is now present in the courtroom. Wheeler, because you failed to comply with the pre-sentence investigation, the court is going to revoke your bond. We're going to take you into custody. Ms. Wagner is going to prepare a pre-sentence report and do an interview with you. And then the court will set this for sentencing at its next available
I
date.
did bring the paperwork today, so can I give it to her today? Oh, so she has it or not?
No, you've had lots of time.
No, I know, I just didn't know if I could still give it to her so she had it.
She will get that from you. Yes.
Okay.
Okay. So Terry, if we can take Ms. Wheeler in custody.
Well, it's good to see you, Kylie. Love you, honey.
I love you.
Our next hearing set for 10 o'clock. We'll be in recess until that time. People versus Richard Trepanier, case number 244891.
Right, Ziegler.
Kyle Travis, on behalf of Mr. Trepanier.
Record should reflect Mr. Trepanier is present here in the courtroom today. This is set for a status conference. I know we had a trial set for January. I believe that we've just adjourned that by stipulation based on basically defense request, right, Mr. Travis?
That is correct.
Okay. So in terms of the status conference, I'm not sure how the parties want to proceed. We also have a couple issues regarding evidentiary matters. And again, with the adjournment of the trial, Mr. Travis, I don't know if those are things that you want to pursue today, or if those are things that you're still looking at, or whether the reasons for adjournment are going to affect those issues or not.
In speaking with Mr. Ziegler, I think our motions are still appropriate. I did identify another, I guess, change in mine and Mr. Ziegler's agreed opinion of what the law was on a different factor, not specific. It is relative to rape shield, but not specifically that motion I filed. It was something we mutually agreed wasn't going to come in.
Okay.
So that's may still be an issue. We're continuing that discussion. It's just, at least in my mind, changed a bit from when I acknowledged that we couldn't talk about certain things. And so we may have something there still. We haven't really digested all that and come to where our position is yet. But relative to the two motions before the court, I think we're largely settled on them. Well, we're not settled, that's to your honor, but our positions are settled. And so there, I guess what I would say is maybe if the court would allow us potentially another date to file a motion, if we, I'm not saying we are or aren't, but we may. I guess let the court know where we stand.
Okay. All right. And then the other thing, Mr. Ziegler, particularly in light of the previous case where I had not gotten a chance to look at your brief, did you file any response briefs to defenses?
I did not, Your Honor.
Okay.
But there is a question, Your Honor, that Mr. Ziegler and I attached a copy of the prelim transcript to mine. Did Your Honor get Mr. Ziegler's full notice? Because that had a copy of the police report attached to it, and that's why I attached.
Yeah.
Okay, and that's, I think, with Mr. Ziegler, and I wasn't sure, that's why I added some more to mine.
Yeah.
He believed you had gotten that. Okay.
I did, and I had a chance to review that. Okay, so did you want to proceed with those hearings today, or did you want to hear all the evidentiary issues together at that later date?
I guess I would leave it. I don't have a
It doesn't
position.
matter to me.
If Mr. Ziegler has a position, I would.
Your Honor, given that defense is unclear whether they're actually going to be filing any additional motions, I'd prefer to just address what we have before us today. And then if there's a future issue, we could deal with it later. But I don't want to get close to trial and not have addressed what's before us already.
Sure. Okay. Sounds good. So, Mr. Travis, your first motion deals with the admission of some prior sexual conduct of the complaining witness under MCL 750.520J. And that's evidence related to two specific instances of sexual intercourse between the defendant and her at a time prior to this, correct?
After.
Oh, it was after. Okay. Anything that you want to add today by way of oral argument in support of your request for the admission of those?
Nothing other than largely, Your Honor, I've been learning more about rape shield through this process. I thought I understood it, but in this situation, as was, Your Honor can see, it was in the police report. We were all aware of it. I later learned, actually, I thought I had to file a notice like the prosecutor does. Later in time, Mr. Ziegler and I discussed that and said, well, just file your notice. As I was doing that, I realized it actually had to be a motion. But I don't think we're really in dispute. Everybody knew about it and kind of thought it was going to come in. It fits within one of the very few exceptions identified in the statute. So I would ask the court to allow it to come in.
So just for purposes of the record, because your motion in brief just kind of made some conclusory statements that fits within the statute, but it is material to a fact issue. So you didn't really specify what it is material to in your written submission, so I'd like to know.
Basically, it's defendant's version of what happened, is that this crime did not happen as alleged. It happened later when alleged victim was not underage. So it is essentially his defense, and it is his counter version of the alleged facts. So I think it's quite material to what he would propose.
So evidence that there was consensual sexual contact between the two of them subsequent to the allegations that give rise to this charge, it's going to be offered to show that either it didn't happen at that time.
Correct.
Okay, that it happened as part of the consensual matters later.
Correct. Over the age
And
of
the
16.
witnesses or the complaining witness is just mistaken about their memory of when it took place.
And other facts, but yes.
Okay, all right, okay, thank you, Mr. Ziegler.
Yeah, that's essentially the issue, is that at certain times, the defense has said that all of the allegedly consensual contact occurred when the victim was 16. At a particular interview, which I intend on presenting at trial, he said that one instance occurred when she was 15, and one when she was 16. Obviously, the victim's version is that she was 15 and that it was all non-consensual contact. If she's 15, it's irrelevant anyway, whether it's consensual or non-consensual. But I do agree Mr. Travis was required to file a motion. I don't have a particular objection to the admission of evidence, or particularly the defendant's statements to the effect that at least one occasion the victim was 16, primarily because that statement is thoroughly interwoven with other statements in his interview with Detective Helene that I take as admissions of the offense. And I think it would be very difficult for me to present that evidence, having to cut out all the references to the fact that there was this alleged additional encounter when she was 16. So for purposes of what's in the motion, I have no objection to it.
Okay. All right, based on the prosecutor's position, and I think, just as a matter of substance, I don't find that evidence to be particularly, prejudicial to the people under a 403 analysis. I do think it's, it is probative as to the relationship between the defendant and the complaining witness. It does tend to show that there were multiple instances. I think given that her age at the time of the alleged offense in this case is an issue. I do think it's any prior instances of sexual conduct between the two of them or subsequent instances would be relevant to the defense and material to the defense. So the court finds that they would be admissible, and so the court will grant the motion limited to those instances to the extent the defense wants to go into any other matters that may be covered by rape shield. Those would have to be dealt with under a separate analysis. So the court will grant that motion. And then Mr. Travis, you objected to the prosecutor's notice under 768.27B as to this prior instance of alleged sexual assault against a different minor in 2018, I believe.
Correct, Your Honor.
So anything that you want to state for the record in support of your objection there?
No, Your Honor, I would leave it to my written objection.
Okay, Mr. Ziegler.
Your Honor, I think I'm calling it a prior act, but it's actually a subsequent act based on the nature of all of this shook out. This case happened back in 2009. It was at that Lund Road address. He allegedly had sex with a 15-year-old. Later in time, either late 2017 or early 2018, he was actually prosecuted for another offense against a minor. I believe the victim in that case was around 13 at the time, and there was some sexual contact between the two of them. He was prosecuted and convicted for that from a CSC second degree. I think rule is quite clear that that's admissible even to show propensity under 76827B and under People versus Pattinson. This is one of those rare occurrences where the legislature has deemed propensity to be relevant. It's also relevant to show common scheme or plan, to show motive, to show that the acts were done for a sexual purpose, to show a lack of mistake, and it's similar conduct against a similar aged victim at the exact same address. So for all of those reasons, Your Honor, I do think that that prior or subsequent act is admissible for those purposes. So I would ask the court to deny defendant's objection to my notice.
All right, thank you, Mr. Travis. Anything you want to state in response?
Nothing further, Your Honor. Thank you.
All right, looking at 768.27B, it does allow the admission of evidence of prior sexual assaults for any purpose for which it's relevant. It expands on what's allowed under the 404B, and as Mr. Ziegler stated, if appropriate and not unduly prejudicial in relation to its probative value, is admissible for purposes of propensity. In analyzing whether or not that type of evidence should be admitted, the court is to look at things such as the similarity between the prior alleged assault, the passage of time. There's the 10-year rule within the statute itself, but the difference in the temporal proximity of the two incidents is a factor that the court is to take into consideration. And again, things like the similarity offense are all factors that the court should look at in determining the probative value of that type of evidence. In this case, the court agrees with people in terms of the similarity in the offense, although this did not involve penetration as the charged offense does. It does involve sexual touching of an individual, teenage individual, female. Although it is 9 years apart, the court finds that it is within the time frame allowed under the statute, and given the factual similarities between the offenses, the court finds that the probative value isn't diminished by the time difference in this case. So the court finds for those reasons that that evidence is admissible, and the court will overrule the objection of the defense. And Mr. Travis, if you could prepare an order that reflects a ruling of the court as to both of those issues.
Yes, sir.
Anything else on the evidentiary issues that we need to address, Mr. Travis?
Not at this time, Your Honor.
Mr. Ziegler? Okay, then in terms of the status conference, the court is just going to reset this for trial if it hasn't already been set. The court will set it for a new final status conference date. That will be the plea and motion cutoff. So to the extent there are any additional motions, Mr. Travis, they could be filed and heard at any time, but no later than the date of that final conference. Mr. Travis, anything further on this file today?
Nothing further, Your Honor.
Mr. Ziegler? Okay. Thank you. That's all for this case today.
Thank you.
Mr. Travis is we have Mr. Canfield. Yes, sure.
Okay.
I can't.
Versus Nathan Canfield, case number 244979. The record should reflect that Mr. Canfield is present here in the courtroom today. If I can have counsel put your appearances on.
Brian Ziegler, yeah.
Kyle Travis on behalf of Mr. Canfield.
Thank you. This is the date and time set for sentencing hearing in this case. Mr. Canfield, have you had a chance to go through the pre-sentence report and talk to Mr. Travis about that? Mr. Travis, are there any additions, deletions, or corrections to that report?
None that I'm aware of, Your Honor.
Any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your
Do you have any victims that wish to address the court today? Anything on behalf of the people for allocution?
Your Honor, I don't have a lot to say on this case. I would largely support the recommendations contained in the PSI. I think defense and I have agreed previously that the restitution amount of $1,000 is appropriate. Essentially, this was a rental or a loaner vehicle that the victims had gotten from a dealership. Mr. Canfield took that without permission, wrecked that. The victims were on the hook for, I guess, a deductible or insurance to compensate. So that $1,000 is for the damage to the vehicle. I think that's appropriate, but in all other respects, the defendant's already served over 3 months for this offense. I think that's probably appropriate given what the plea agreement was. And obviously the fines and costs are appropriate, statutorily required. So I would ask the court to adopt the recommendations.
Thank you, Mr. Travis.
Thank you, Your Honor. Your Honor, we would agree, we have agreed to the $1,000 of restitution. That is appropriate. I believe that's the out-of-pocket cost to the victims. I mean, the car was damaged. I don't believe it was totaled. I think he hit a guardrail. But any damage to a car nowadays is outrageous. So largely, we would ask the court to follow the recommendations. Mr. Canfield does have a longtime good friend who is established in North Dakota and has employment for him. Basically, as soon as he can get out there, it's his desire to get out there, start making some money. He knows he's got to come up with a good chunk of money to pay this off, and then there's going to be some fines and costs. But he has he believes to be a good environment. He, as Your Honor can see, there is a history of substance abuse and things. He doesn't necessarily want to go back home. Actually, when he was up here, he was doing fairly well. He had kind of gotten out of his existing environment, and he was more deeply tied to these folks than maybe it would seem. It was actually his boss, who was the owner of the house and the car. He had been doing pretty well while he was up here, but obviously this incident was not a good behavior or a good move. But he wants to get back to working and understands that he probably shouldn't go back to Southwest Michigan because he's struggled to stay away from substances there and keep on track. Thank you.
All right, thank you. Mr. Canfield, anything you wanted to say today?
I'm just trying to move on my life, honestly. I know what I need to do. It's just a matter of doing it. I mean, this charge is from almost 2 years ago. So, I mean, I was already starting over and trying to, get in the right direction. And here I am being forced to start over again. So it's just trying to get there and get it done too.
All right, I did read through the report. I'm familiar with what happened in this case. It sounds like you took the car a couple times. They told you not to do it and just kept using the vehicle until this incident happened. And you certainly have, a long history, 23 misdemeanors, 4 felonies. Been on probation 7 times, jail 19 times. I don't see probation as being helpful in this case. 7 prior times hasn't done the trick. I don't think 1 more time is going to do it. You're 40 years old. At this point, you're either going to stop doing this kind of stuff or you're not. So I do think in terms of upfront jail, I do think that the time that you served is sufficient given the nature of the crime in this case. I do think restitution is appropriate, but I do want to monitor whether or not that's being paid, because these folks deserve to get that money back. And so what I'm going to do is I'm going to impose 99 days of jail up front. I'm going to hold a lot of jail time in advance. I'm going to set this for a hearing in about 6 months. And if that restitution is not paid or a substantial portion of it isn't paid, you're going to need to provide me with some evidence, some documentary evidence of why you haven't made progress towards that restitution in that amount of time. And if you don't do that, then then you'll have to serve more jail time, because if you're not paying the restitution back, to me, that's the most important part of this at this point. So as to count one, the operating with license suspended, the court is going to sentence you to $53 state costs. As to count two, which is the unlawful use of a motor vehicle, the court is going to sentence you to restitution in the amount of $1,000 that's payable to the Kalkaska County Clerk to be dispersed to Joshua Paris. A crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. On that charge, the court is going to order that you serve 11 months in the Kalkaska County Jail with credit for 99 days. The court is going to order that the balance between the 99 days and the 11 months be held in abeyance, pending a review hearing on payment of restitution, which the court is going to set for 6 months. And as to count three, the failure to report an accident, $53 state cost. You do have the ability to appeal the sentence, and we're going to provide you with papers that explain to you what your appellate rights are, as well as how to request a court appointed attorney to help you with any appeal.
Your Honor, just a clarifying question. He wouldn't technically be on bond, so he would be able to go work in North Dakota?
Yes.
Okay.
Yeah, I mean, there won't be any restrictions on that other than
So he's got to come back and warrant in the state of Michigan and the remainder of a year to serve.
right. Thank you.
Thank you, Your Honor.
Good luck to you going forward, Mr. Canfield. People versus Helsel, we're a couple minutes early. We're going to call the case at this point. Okay, Mr. Travis, any sign or word from Ms. Helsel?
No, unfortunately, Your Honor, not. I know we were here last time. I made some calls that day. I made some calls interim, just a couple days ago. And here we've got court. I have heard nothing since the last court date.
Okay. All right, at this point, the court is going to order that Ms. Helsel's bond be revoked. Court will request people to issue a bench warrant for her arrest. Once she's arrested, court will order that she be held without bond in the Kalkaska County Jail, and then the court will set sentencing at its next available date.
So, Your Honor, I have a bench warrant signed by Your Honor on December 3rd. So I think there's already.
You already got an active one?
I believe so, Your Honor.
Okay. Okay.
So unless the court needs an additional one, I think we're good.
No, as long as we have one in the system so that if she's picked up, we can get a hold of her so we can conduct the sentencing.
Thank you.
All right, thank you. Next hearing set for 10:45 will be in recess until that time. we're on the record in Parker, People versus Parker Peterson, case number 244970. The record should reflect that Mr. Peterson is present here in the courtroom today. If I could have counsel.
Brian Ziegler on behalf of the people, Your Honor.
James Hunt on behalf of the defendants, Your Honor.
Thank you. This is the date and time set for sentencing in this matter. Mr. Hunt, just to make you aware, I am in receipt of a number of documents. Letter from Mr. Peterson himself, a student schedule for Grand Valley State. A letter from the mental health.
Yeah, I think there was a counselor that wrote a letter as well.
From Mr. Boonstruck. I had a chance to review all of those prior to the hearing today. Mr. Peterson, did you have an opportunity to go through that pre-sentence report and talk to Mr. Hunt about that?
I did.
Okay. Mr. Hunt, are there any additions, deletions, or corrections that need to be made to that report?
No, Your Honor.
Are there any challenge to the scoring of the guidelines?
No, I believe the scoring is correct, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything that you wish to state for allocution on behalf of the people?
Your Honor, I largely agree with the recommendations contained in the report. I'm sure the court has read through the description of the offense. It's shocking to me that no one was injured as a result of the defendant's conduct. He was traveling at a very high rate of speed. At some point, he struck a deer and he continued to flee the police, and the chase only ended as a result of the defendant crashing his vehicle. I don't know how he wasn't more seriously injured as a result of this course of conduct, and I'm glad he wasn't. I'm glad law enforcement in either county was not injured either. But it was a very dangerous thing to do. It was a very stupid thing to do. But I think that's exactly what the point of the HIDA statute is. This defendant is quite young. He's 19 years of age. He made a very poor decision as a result of his youth. I'm hoping he's learned a great deal as a result of this. I think he will benefit greatly from having an opportunity at HIDA probation. So I think the recommendation is appropriate. I would ask the court to place him on HIDA probation, give him an opportunity to demonstrate that he can make better decisions in the future and to keep this off of his permanent record.
Thank you, Mr. Hunt. Anything on behalf of Mr. Peterson today?
Yes, Your Honor. I've known Parker his entire life. I get calls in the middle of the night on numerous occasions from clients or potential clients. This one that I received about 2 or 3 o'clock in the morning was a shock to me. If there was anybody that I would not have expected to have a call about, it would have been Parker. Parker is a very fine young gentleman. He's been extremely successful up to this point in time. He was a good student. He was a good athlete. He obviously has been goal oriented. He's somewhat of a shy, I will tell you, he's a very shy individual. And he was the last person in the world that I would have expected to be in this situation. And I think, as the prosecutor pointed out, this was just a very foolish, rational or irrational decision that he made, that once he was going to be pulled over, he decided to take off. And I think things just snowballed from there. He didn't know what to do. It was very fortunate that nobody was injured, including himself. And it was after the accident, I watched the body cam footage. The investigating officer from Kalkaska was extremely nice to Parker after it occurred. He said, "Man, why did you run? This is a traffic ticket that you turned into a felony." And, Parker was very courteous to him. They had a conversation, and it was almost like a dad talking to a son saying, "Why did you do this?" And I know that Parker has regretted this. And I think it's one of those things that maybe when we're young, we don't think things through. But I think he's got a very bright future ahead of him. As you noticed, he was a good student in high school, was attending college part-time while he was in high school. He's goal-oriented. He's a hard worker. He's had jobs most of his life. He's got parents who are in the courtroom today that are concerned about him. I will tell you that After this happened, they got him involved with the counselor because they wanted to know why this happened. They wanted to make sure this wasn't something that they needed to deal with. And they also took appropriate action in sanctioning him for what occurred. They did not take this lightly. As you noticed probably from the report as well, my client lost his license for a year by the Secretary of State. That was done, I believe, in November. So that's another sanction that he's living with as well. I know in my conversations with him, he has nothing but remorse and I guess has tried to work through this in his mind as much as he could. I agree with the prosecutor that this is the type of situation that HIDA was made for, to give an individual an opportunity for a second chance to not have this on his record to impede him in any way. I think Parker is going to be a very successful person in the future. And I cannot imagine anything similar to this or anything at all where he would be involved in the criminal justice system after this. And I believe he'll prove to you during any type of very extended period that he is a different person than what this incident would indicate.
All right, thank you. Mr. Peterson, anything you wanted to say?
I do have something. And I'm truly sorry for what I did with running from the cops, because what I should have done was just pull over and face the consequences for my action. But then I got scared and then I decided to run, which was the worst decision I could have made, resulting in a felony rather than just a ticket. And I not only put myself at risk, I put the cops at risk, which I am truly sorry for it, along with all the people on the road at that time. And but since then I've done more. I've tried to better myself with getting enrolled in counseling. I have also been taking this time to work towards my builder's license, in which I have taken college off for this last semester, in which I do. I will be re-enrolling next semester to finish up some more credits for my associate's degree, help me transfer towards Grand Valley, which I will be attending next year.
Okay. All right, I did read through the report, so I'm familiar based on the information in that report with what happened. There's also a lot of information in there about you and your background and circumstances, along with the letters that were submitted, which I read very carefully. And I think the lawyers and yourself are right. This could have ended in a much different way. You could be here for a much different reason now, which is causing an injury or death of someone else. You could be recovering from injuries or have permanent injuries yourself as a result of this. So I hope that you don't, I hope you're not just saying it because you really could have injured or killed somebody, and that's a whole different thing to live with than just knowing that you made a mistake. I also think it's a great idea that you're seeking some counseling. When somebody who has never really had any problems suddenly gets himself into this kind of situation and does something so out of character, I know as a parent I would be wondering what's going on. Is there something here deeper that we need to take a look at? So, and maybe there is, maybe there isn't, you know, I don't know, but I think it's smart and a really good idea to get some counseling to try and get at the core of why you did this. And if there is some kind of reason for that, that it gets dealt with. And if there isn't, if this was just a youthful, spontaneous, spur of the moment thing, then you've at least looked into that possibility. So I think that's a really good idea, and I hope that you continue with that as well. All of that being said, there's every indication that based on your family support, based on your prior history, based on what your plans are going forward, that you can be successful and complete this probation and have this come off your record, which is going to be incredibly important, especially if you want to be a builder. You're not going to be able to get a builder's license with a felony on your record. There's a lot of benefits to you going forward, and I agree with Mr. Ziegler. This type of probation is designed for these kind of situations where a young person who otherwise hasn't been in any trouble and is likely to not be in trouble again, and have this be a, you know, just a speed bump in your past as opposed to a huge roadblock to you. So I hope that you do take the probation seriously. I hope you follow through with it. All of us want to see you come out of this and go forward. If you don't, however, and you are back in front of me. I'm not gonna impose any jail time today. But if you violate your probation in some way, that's gonna be telling me something about how seriously you're taking this, and it's gonna result in some consequences. So I want you to understand that. To the extent that you don't comply, things are gonna get more serious from here on out. So I do think the recommendation is appropriate. I am gonna follow that recommendation and sentence you to 12 months of probation pursuant to the Homes Youthful Trainee Act. The court is going to adopt as the conditions of your probation all the terms and conditions listed in the report. The court is going to impose 90 days in the Kalkaska County Jail with credit for 2 days served. I'm gonna hold that time in advance, so if you successfully complete your probation, you'll never have to serve that time. The court is going to order that you pay a crime victims assessment of $130, supervision fee of $30 per month while you're on probation. Court costs of $325, fine of $250, a DNA testing fee of $60, and a $68 state cost. Because the sentence is pursuant to HIDA, there are no written appellate rights at this time. It's just important, Mr. Peterson, that you make sure that Ms. Wagner, are you the supervising agent?
Yes, Your Honor.
Make sure that you touch base with Ms. Wagner, make sure that you're clear on all the conditions of your probation. And again, good luck to you. I hope you move forward from this.
Thank you. Thank you, Your Honor.
Yeah.
All right, the court's next hearing is set for 11 a.m. We'll be in recess until that time. right, Mr. Williams, are you able to hear me okay?
Yes, Your Honor.
Okay. All right, we're on the record in People versus Owens, case number 244948. We have Mr. Owens present here in the courtroom. Mr. Williams is appearing by Zoom by prior request due to illness. Mr. Ziegler is present here in the courtroom today. This is the date and time set for sentencing in this case. And Mr. Owens, did you have a chance to go through the pre-sentence report and talk to Mr. Williams about that?
Yes, Your Honor.
Okay. And Mr. Williams, are there any additions, deletions, or corrections that need to be made?
I just would note that the cocaine positive was prior to him being released from jail. It was a drug test taken when he was arrested, and ever since then and throughout this entire case, he did not have any issues on bond. It just was confusing how it read in the PSI.
Okay, the court will note that. There are no guidelines since this is a misdemeanor. Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Anything on behalf, oh, I'm sorry, do you have any victims that wish to address?
No, Your Honor, I don't believe Mr. Rogers is present.
Okay. Anything on behalf of the people for allocation today?
Your Honor, I often make offers like the one in this case where there's some restitution owed, and the primary point of the case is restitution. Sometimes I do that with the expectation that that person will pay the restitution and take the benefit of the plea deal, and sometimes I do that assuming that probably won't happen. In this case, I kind of assumed it probably would not happen. There was about $16,700 of restitution. I made the offer. I figured if the offer was accepted and the restitution was paid up front, that would be fantastic. I didn't really expect it. The defendant has traversed a lot of hurdles, overcome a lot of obstacles, and has actually come through on the restitution. I can confirm that since the time the PSI was filed, every single dollar and cent of restitution has been paid in full to the victim. And so for those reasons, Your Honor, I do think the recommendations contained in the PSI are appropriate. I think the defendant has fully earned the reduction in the charge that he's gained as part of the plea agreement. The victim has been made whole. I don't see that there is a lot of point to a continuing term of probation or anything like that. So I would ask the court to adopt the recommendation for a sentence of fines and costs. I don't believe the court needs to order restitution because, like I said, it's already been addressed.
Thank you. Mr. Williams, anything on behalf of Mr. Owens today?
I think that as a first for everything, Mr. Ziegler allocated eloquently. I would leave his allocution. I agree.
All right, thank you. Mr. Owens, anything that you wanted to say today?
Outside of you guys letting me have the time to pay it off, no, sir. So I appreciate that.
All right, I did read through the report. I'm familiar with what brings you before the court here as part of this case. There's also some information in that report about yourself and your background. I take all that into consideration along with what the lawyers and yourself had to say here today. You know, this is concerning behavior. I hope this is something that you aren't going to repeat again. I hope that this experience has provided enough of you know, a motivation for you to avoid this kind of conduct going forward. I do think it's a promising sign that you did pay all that restitution. It was a significant amount. That indicates to me that you truly are remorseful and that you want to make this right and move on from it. And that, again, encourages me that this is something that you wouldn't repeat. You have a very limited prior history. And so I have every reason to expect that you're going to move on from this and not repeat this kind of incident. So as to count one, the court is going to sentence you to fines, costs. You've already paid the restitution, so $130 in a crime victims assessment, court costs of $325 and a $55 state cost. The court is going to order that you serve 1 day in the Kalkaska County Jail with credit for 1 day served. You do have the ability to seek an appeal of this sentence. If you wanted to do that, you would need to file your appeal in the next 21 days. If you have more questions about that, I'm sure Mr. Williams would be able to answer any questions you have about your appellate rights. This way.
Oh, just real quick, Your Honor, I think, and looking at this is a misdemeanor. I think the crime victim fee should be $75. I think the 130 is based on the felony.
Okay. So the court will change that to a $75 crime victims assessment instead of 130. Mr. Williams, anything further that we needed to address today for the record?
No, Your Honor, thank you.
Mr. Ziegler.
No, Your Honor.
Okay, so Mr. Owens, just go across the way to the clerk's office to make arrangements to pay the rest of those costs, and good luck to you going forward.
Thank you, Your Honor. Thank you, Jesse.
You're welcome.
Mr. Williams, you're free to disconnect.
Thank you.
Next case is Mr. English. That is going to be a Zoom. I don't see them in the waiting room yet, so I'll recess until People versus Matthews, case number 244978. If I could have counsel put your appearance on, please.
Brian Ziegler on behalf of the people, Your Honor.
Good afternoon, Mayor Police Report Brandon Davis, P 74251 on behalf of the defendant.
Okay, thank you. This is set for a status conference in this case today, and scheduling, I believe this is Mr. Matthews' first appearance before the circuit court. Mr. Davis, can you tell me the status of this file?
Yeah, we're still at a place where the defense is hoping to continue to negotiate on this case. We're also would be seeking a Cobb's evaluation, the opportunity to talk about this matter with the court.
Okay. Mr. Ziegler, have there been any plea offers?
Your Honor, the offer would be to plead to count 1, which is the delivery manufacture of methamphetamine. In exchange, count 2 would be dismissed. There's also some related potential charges arising out of the same incident that would not be charged.
Okay. All right, so Mr. Davis, the court, I don't engage in Cobb's negotiations. If the prosecutor and yourself want to agree on a sentence like a Killebrew arrangement where the court's not bound, I don't have any objection to that. But in terms of the Cobb's, I generally don't do Cobb's. So that being said, do you want to set like a plea cutoff so that you have some time to talk to your client and further negotiate with Mr. Ziegler?
Yes, Your Honor, we would request that. Would the court engage in a conversation? It's my first time practicing before the court, and I want to have some type of understanding in order to advise my client well.
Sure. Yeah, no, I don't engage in any kind of pre-plea sentence discussions or negotiations with counsel. So typically, again, to the extent there's an agreement, we treat it as a Killebrew, where if after reviewing PSI, I don't elect to adopt the agreement between counsel, I'll notify the defendant, tell them the sentence I would intend to impose, and then give the defendant an opportunity to either accept that sentence or withdraw the plea.
Understood.
And go back. So are you waiting on, any kind of test results, or is there any discovery that would affect the plea negotiations that you're waiting on?
To my understanding, probably a question to the prosecutor, but I believe I have everything at this point.
I believe the defense has everything that I have, Your Honor. There's no outstanding tests that I'm aware of.
Okay. All right. So I guess, Mr. Davis, my suggestion would be, we set this for a status conference plea hearing in 30 days. If at that point your client does not want to enter into any kind of plea, then we would get it on the trial track. Do you have any objection to that?
I have no objection to that. Just looking at dates.
I won't schedule it today.
Okay, got it.
I've learned not to schedule from the bench. So.
I appreciate it.
It'll be likely the Tuesday of the first full week in February. He's not here, so I don't have that date.
Looks like it's the 4th.
Or yeah, so it'll likely be that date.
Would the court allow us to appear virtually? We're over 2 hours away.
Yes, if you make a written request prior to the hearing, I have no problem.
Thank you. And that's just an email to the clerk or some type of motion?
Nope, just a written request by email to my assistant, Jennifer.
Thank you.
Yeah. Okay. Mr. Ziegler, anything else? Mr. Davis, anything else that you need to address from yourself?
Nothing, thank you.
Okay, thank you. We'll send out notice of the date and time of that hearing. To Mr. Matthews and to Mr. Davis.
Thank you very much.
Mr. Horowitz, are you ready? I think we have Mr. English connected.
Yes, correct.
So, as somebody from the Department of Corrections, can I say?
That is him.
All right, Mr. English, are you able to hear me okay?
Yeah.
Okay. All right, we'll go on the record in People versus Michael English, case number 244923 and 244925. The record should reflect Mr. English's appearance today by video from Department of Corrections. I'd like to have counsel to your appearances on.
Brian Ziegler on behalf of the people, Your Honor.
Michael Horowitz on behalf of Mr.
We're set for status conference in both of these files today. Horowitz.
Your Honor, unfortunately, Mr. English is in the Egler Reception Center, which is MDOC's basically sorting and quarantine facility when people enter MDOC custody. And because of that status, I have not been able to have contact with Mr. English. I have been in contact with Mr. English's significant other, who I believe may have relayed some communications with him. But I think until he exits quarantine, it's not really possible to have meaningful communication with him. I think that I would ask him today if he knows what his exit date is. I believe that he received 2 summonses out of Wexford, one of 2 to 4 years and one of 2 to 5 years. And so if he knows where he's going or what he's getting out of RGC, that'd probably be helpful in terms of figuring out how to schedule it.
Mr. English, do you know when you're going to be sent to a different facility from where you're at now? Have they given you any information on that?
No.
Do you have access to the phones yet?
I get it. No, they don't give us phones really.
Usually it's 45 to 90
Say
days.
six weeks usually. When do you know when he got there, Mr. Hood?
I've been here for 49 days.
Yeah, it would have been the last hearing. It was the week before the last hearing.
Okay.
I believe. So that seems about right, what he said.
Mr. Ziegler.
Your Honor, under the circumstances, I don't see that we have any choice but to adjourn it out for a period of time.
All right. We may have already had this discussion. Council can remind me, but in terms of, are these files related? Are you going to be seeking to try these together if we go to trial?
They're not related to the degree that I would move to join them, Your Honor. They'd be separate trials.
And is there a file that you're asking to have tried first?
I guess I don't have a particular preference, Your Honor.
Mr. Horowitz.
We don't have a preference as to what is tried first, but I have been under the understanding that people would proceed with the alleged fleeing and eluding first. I don't know where I got the impression, but I'm not necessarily relying on it. Just I think there was some talk of that at some point.
Okay, what I would like to do for today's purposes then, and that's file number 244923. I would like to at least get a you did a scheduling order in the other file already. I think probably the best course of action at this point is to set these for another status conference following Mr. English's release from the Egler facility so that you can have contact with them. I think rather than setting a bunch of dates today, do you have any objection to that, Mr. Ziegler?
No, Your Honor.
Okay. All right, so I'm going to set this for another hearing in about 30 days. Mr. Ziegler, if you could do another writ. Mr. English, we're going to set this out so that you can have an opportunity to speak with Mr. Horowitz. Once you're released from the Egler facility, you should be able to do that. And then we'll proceed further with scheduling of these cases so that we can move them along. Mr. English, do you have any questions about that?
No.
Mr. Horowitz, anything further for the record?
No, Judge, thank you.
Mr. Ziegler?
No, Your Honor.
Okay. All right, thank you. That's all for this hearing today, and the court's going to disconnect at this time.
Your Honor, I believe that's all I have in front of the court today.
Yes, thank you.
Thank you.
Mr. Travis, were you ready on Mr. Evans' case?
Yeah, Your Honor.
People versus Evans, case number 244967. The record should reflect that Mr. Evans is present here in the courtroom today. If I can have counsel for your appearance.
Ryan Ziegler, yeah, people, Your Honor.
Kyle Travis on behalf of Mr. Evans.
All right, this is the date and time set for sentencing in this matter. Mr. Evans, have you had a chance to go through the pre-sentence report and speak to Mr. Travis about that?
I have, Your Honor.
Mr. Travis, are there any additions, deletions, or corrections?
Not that I'm aware of, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the guidelines?
No, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, the plea agreement calls for a sentence of 7411. I continue to believe that that's an appropriate sentence in this matter. It seems to me, in reviewing the facts of the case as well as the defendant's description of the offense, this has been something of a wake-up call for him. I think it's particularly noteworthy that he acquired this substance, believed it was cocaine, and then later it tested presumptive positive for fentanyl. This is exactly how people die from using controlled substances. It happens all the time. It's happened many times in this county, and I've been involved in those cases. I hope Mr. Evans understands that had he used that substance, things might have gone very badly for him. I think he does understand that the intervention of law enforcement in that day may have saved his life, or at the very least saved him from having a very negative experience with controlled substances. So hopefully he understands all that, I hope, and I think he will do well on 7411 probation. I would ask the court to adopt the recommendations and give him that opportunity.
Mr. Travis?
Thank you, Your Honor. We would ask the court to adopt the recommendations. I would echo having talked with Mr. Evans about this. He was very shocked to find out what it was. I would note, kind of leading into this, I think you would acknowledge he was not doing that well. He's got a bit of jail time under his belt on this case because his parents are quite supportive of him, but they were quite concerned about his behavior leading into this. I think he was eventually able to convince them that he wanted to stop using substances because I think they were rather frustrated with him related to that. And they helped him get out of jail. He's working, he's doing well, he's on the right track. So I do think from speaking with him, from seeing how his family reacted, he was not really in the direction he wanted to be or his family wanted him to be, but he is now. And that's what 7411 is for. And we would ask the court to adopt that recommendation. Thank you.
All right, thank you. Anything you wanted to say, sir?
I mean, they pretty much nailed it on the head. I wasn't doing well at all. And I felt I was completely trapped during that whole time. And it took me, it took what happened and for me to go to jail and get my mind back to get away from that crap. And I haven't thought about going back once. I'm doing great now. So I would really appreciate a 7411. Got a great job. I've came leaps and bounds since then, and I'm glad it happened because my life wasn't going very well up till that point.
Okay. I did read through the report. I'm familiar with what happened in this case. I'm also familiar with your circumstances and background based on the information in that report. And don't have a real lengthy history. You got a couple blips there, but certainly nothing to the extent of what you got involved in here. And I think, at 30 years old, you're 30, right?
Yes, Your Honor.
At 30 years old, you're kind of at a crossroads at this point. The things that you did in your 20s aren't sustainable as you get older. And you need to either make a change or things are going to get worse from here on out. And so I hope that you're sincere in your statements here today that you do want to make that change. I think it's appropriate, given your lack of any substantial history, to give you an opportunity at that through probation and, through the 7411 to avoid this being a felony going on your record. So I do agree with the recommendation. I'm going to hold some jail time over your head so that you understand that to the extent you don't make those changes, and you don't comply with probation, that there's gonna be a period of jail as a consequence to that. And when the court holds time in abeyance, I can impose that time, you know, immediately if you violate your probation. I don't have to wait for the violation to wend its way through the court system because I'm holding that time in abeyance. So to the extent that you don't comply, consequence will be swift. But I hope that you do. I hope that this is a wake-up call for you. It certainly is. Could have turned out way differently than it did. And I hope that you do go forward and that you comply with your probation and that you move on to something better. So the court is going to adopt as the conditions of your probation all the terms and conditions listed in the report. That probation to be for a term of 12 months pursuant to 7411. The court is going to sentence you to 6 months in the Kalkaska County Jail. You do have credit for 11 days served. The court will hold that time in abeyance. The court will order that you pay a crime victim's assessment of $130, court costs of $325, attorney fees of $350, a DNA testing fee of $60, $68 state cost, and a $30 supervision fee per month while you're on probation. Because this is pursuant to 7411, there are no appellate rights at this time. It's just important that you touch base with Ms. Wagner here today to go through your terms of probation. Mr. Travis, anything further that we need to address for the record?
Nothing further, thank you.
Mr. Ziegler?
No, Your Honor.
Mr. Evans, good luck to you going forward.
Thank you, I appreciate it.
Concludes the court's morning docket. The court will be in recess until 11:30.